and welcome to Legal Talk. Today on Legal Talk, we are going to take a deep dive into China's new personal information protection laws to understand what they might mean for Australian businesses. I'm Alison Cripps, legal writer for LexisNexis Practical Guidance, Cybersecurity, Data Protection and Privacy. Today, I'm joined by Mr. Wang, partner of Zonglung Law Firm in the People's Republic of China, and a specialist legal practitioner in personal data protection, cybersecurity, cross-border M&A transactions, and general corporate. Wayne is admitted to practice as a lawyer in mainland China, Hong Kong, and Australia. He advises many Australian companies on how to do business in China and is uniquely placed as both an Australian and a Chinese lawyer to understand the needs of Australian clients and guide them through complex legal issues relevant to the People's Republic of China. Welcome, Wayne.
Thank you, Alison.
Can you tell us about China's new personal information protection laws? What is the intention of these new laws, and when did they commence in China?
The PIPL, we call it the PIPL, is the Personal Information Protection Law. It was promulgated by the Standing Committee of the National People's Congress in August of 2021, and it became effective on 1 November of 2021. Its intention is to protect the rights and interests of individuals in relation to personal information, regulate the processing of personal information activities, and promote the reasonable use of personal information.
What's the application scope of the PIPL?
Firstly, the PIPL applies to any processing of personal information within China. So regardless of whether the processing is conducted by PRC entities or PRC subsidiaries of Australian companies, it is subject to the PIPL as long as the processing activity occurs in China. And secondly, it has extraterritorial effect to some extent. The PIPL applies to the processing of PI personal information outside of China under any of the following circumstances. For example, it is processed for the purpose of providing products or service to natural persons located in China, or it is processed for analyzing and or assessing the conduct of natural persons in China, or it is processed in any other circumstance as provided by PRC laws or regulations.
What exactly is personal information under the PIPL?
Personal information is defined as any kind of information related to an identified or identifiable natural person recorded by electronic or other means, but excluding anonymized information. For example, the name, the date of birth, the ID card number, address, telephone number, bank account information of any individual.
So if I was to collect employment data, such as the residential address of my Chinese employees or the vaccination status of my Chinese-based staff, I would be collecting personal information. But if I was collecting anonymized click data of Chinese customers, that wouldn't be personal information?
Yes, as long as the information cannot be used to identify any specific individual, it is called anonymized personal information.
And what about processing, Wayne? What is meant by processing personal information?
Processing is broadly defined as activities including collection, storage, use, processing, transmission, provision, disclosure, and deletion of PI. So it basically includes everything.
It applies in mainland China. What if I'm processing personal information in Hong Kong?
Politically, Hong Kong is a part of China, is a special administrative region of China. But technically, Hong Kong is a separate jurisdiction under the so-called One China, Two Systems principle set out in China's constitution. So the PIPL does not apply to Hong Kong. If there's a cross-border transmission of personal information from mainland China to Hong Kong, it will be regulated by the PIPL as a cross-border transmission.
So the fundamental question for our listeners, how does it affect Australian businesses if they don't have commercial presence in mainland China?
As said, the PIPL has extra jurisdictional effect to some extent. Australian companies should consider whether their activities in Australia could trigger the application of the PIPL. For example, if you run an e-commerce website in Australia, if you have Chinese language web pages, you have Chinese speaking customer hotline, and Chinese marketing materials specifically targeting customers in China, such as you are conducting marketing campaigns during the public holiday in China, then the PIPL may apply to you because you apparently envisage to sell products to Chinese individuals.
What about Australian businesses that process the personal data of foreigners, such as Australian expatriates that are living in China? Does the PIPL apply then?
Firstly, it depends on the location of the processing activity. If the processing occurs in China, then the PIPL will apply to it. If the processing activity is outside of China, then it's about the extraterritorial effect of the PIPL. Foreigners who are ordinarily living in China will be considered as individuals in China, according to the PIPL. And the PIPL will apply if the processing activity of the Australian business in Australia falls under any of the following situation. As I mentioned before, firstly, it's for the purpose of providing products or service to natural persons in China. And secondly, it's for analyzing and or assessing the conduct of natural persons in China, or it is in any other circumstance as provided by PRC laws or regulations.
So if an Australian business processes personal data of PRC nationals who are living in China, what are the compliance requirements?
There are various compliance requirements under the PIPL. First of all, you need to comply with the following key principles as set out in the PIPL. The first principle is called lawfulness, necessity, and good faith. You must ensure that the process of PI is carried out legally and properly based on the principle of necessity and integrity. You must not use misleading, fraudulent, or coercive means to process PI. Practically speaking, in most cases, you should obtain the individual's consent. And if a PRC company engages you, an Australian company, to process PI in Australia, you should sign a contract with that PRC company and ask them to undertake that they have complied with the PIPL in providing the PI to you. The second principle is limited scope and minimal impact. You should process PI for clear and reasonable purpose in a manner that have minimal impact on personal rights and interests, and to the minimal scope required for achieving the processing purpose. For example, you should avoid over-collection of PI, and you should collect the minimal amount of personal data required for your purpose. The third principle is transparency. You should process PI openly and transparently. You should disclose the rules for processing PI and expressly indicate the purpose, method, scope of processing PI. The individuals should have the right to know and give their consent. Practically speaking, you should display a privacy notice when an individual clicks on your website. The fourth principle is accuracy and completeness. You should ensure the accuracy and completeness of PI. You shall avoid adverse impacts on the rights and interests of individuals caused by inaccurate or incomplete PI. And the fifth principle is accountability and security. You shall take responsibility for your PI processing activities and take necessary measures to ensure security of the PI that you process. Other than the 5 principles as mentioned, secondly, you shall also establish a special agency or designate a representative in China to be responsible for handling PI matters and report to the relevant PRC authority. And finally, practically speaking, it is advisable for you to engage PRC legal advisors to review your current data collection, data processing procedures, and privacy policies.
And what if I'm wanting to transfer personal data from China to Australia? Like, for example, if I have employees in China and I want to keep their employee records in my Melbourne head office, how do I transfer personal data from China to Australia? What are the legal requirements?
Firstly, there are the general requirements. These requirements will apply regardless of how much personal data that you are transferring to overseas. So according to the general requirements, you shall notify the relevant individual of the overseas recipient's name and contact information, the purpose for the processing and the processing method, the categories of PI that will be transferred, and the methods of which the individual may exercise his or her rights provided in the PIPL, and other relevant matters. And you shall also obtain the individual's separate consent rather than collective consent. What is separate consent? For example, if you run a website, you may need to set up a separate pop-up to inform the user. You cannot rely on a collective or a whole package notice of all PI-related policies on a single web page. And thirdly, you shall conduct an impact assessment for cross-border transfer of PI. According to the relevant rules, the impact assessment shall at least include the following items. Number 8, whether the provision of personal information abroad complies with the PRC laws. Number 2, what is the impact on the rights and interests of the personal information owner? Number 3, the impact of the legal environment and network security of the overseas country and region. And number 4, other relevant matters for safeguarding the rights and interests of personal information. Next point is you shall also take necessary measures to ensure that the overseas recipient will be bound by the PI protection obligations at a standard not lower than those set out in the PIPL. So in the case that you just mentioned, the Australian company shall comply with the above requirements. These are the general requirements. Secondly, there are the special requirements for large quantity processors. So if you are a critical information infrastructure operator, we call it CIIO, or if you are a processor with a process PI amount exceeding the quantity threshold specified by the PRC government. Currently, the threshold is about 1 million individual. Then other than the general requirements, you must also meet all of the following conditions before transferring any PI abroad. The first condition is that you shall store the PI collected in the PRC. You shall pass the security assessment organized by the PRC authority unless otherwise provided by laws, regulations, or the PRC authority. If you are not a CIIO processor and the PI you process is below the quantity threshold, then other than the general requirements, you must also meet one of the following conditions. I said one of rather than all of the following conditions. The first condition is that you shall obtain the PI protection certification from a specialized institution designated by CAC. But currently, details of such certification process remain to be clarified by further regulations. Second condition is that you shall conclude a contract with the overseas recipient based on the model contract developed by the CAC, the PRC regulator. You shall agree on both parties' rights and obligations in the contract. But practically speaking, the model contract is not yet available for now. And the third condition is you should meet other conditions provided in laws or regulations of the authority.
If a PRC company engages an Australian company to process certain personal data, what are the compliance obligations for both of them?
In this scenario, the PRC company is the provider of PI, while the Australian company is the recipient of the PI. The PRC company will collect the PI and then transfer it to the Australian company for processing in Australia. So the PRC company shall sign a standard engagement contract with the Australian company regarding the PI processing activity. And the PRC company shall meet the following requirements. For example, it shall notify the individual of the overseas recipient's relevant information, including the recipient's name, contact, the processing purpose, and the processing method. The PRC company shall obtain the individual's separate consent and conduct an impact assessment for cross-border transfer of PI and keep record of the assessment. The PRC company shall also take necessary measures to ensure that the overseas recipient will be bound by PI protection obligations at standards not lower than those set out in the PIPL. The Australian company shall perform their obligations under the engagement contract with the PRC company. And the engagement contract should include the following provisions. For example, the purpose and period of the entrustment of processing, the processing method and the type of PI, the protection measures, and the rights and obligations of both parties. Practically speaking, the Australian company shall process PI in accordance with the contract with the PRC provider and shall not process PI beyond the agreed purpose set out in the contract. If the contract is withdrawn or terminated or ineffective, the Australian company shall return the PI to the provider or destroy it.
Some of our listeners out there might be thinking that this sounds very similar to Europe's General Data Protection Regulation. For those listeners that don't know, the EU's General Data Protection Regulation, or GDPR, was adopted by the European Parliament in 2018 and applies a regime for collection of personal information in Europe. Like PIPL, the GDPR has extraterritorial reach, regulating organisations, including Australian organisations, that handle the personal information of Europeans outside of Europe. How similar is the PIPL to the GDPR? Can Australian organisations that comply with the GDPR safely assume they will also comply with the PIPL?
It is similar, but there are also many different provisions. You cannot assume that you will comply with the PIPL if you have complied with the GDPR. For example, the PIPL has a unique concept called sensitive personal information. And the requirement of separate consent is also unique in the PIPL. And there are also many regulations in the PRC that are specific to certain industries. For example, there are special requirements for the processing of personal information in the automotive industry, the financial industry, and in the medical and health industry.
Interested, Wayne, in what sensitive personal information is. Is this what we would assume would be information pertaining to minors, or is it broader than that? And what are the requirements for processing and transferring it to overseas?
Yes, it includes the personal information of minors under the age of 14. But the definition of sensitive PI is any PI that, once leaked or illegally used, can easily result in infringement of personal dignity or harming personal and property safety of a natural person, including information such as biometric identification, religious belief, specific identities, medical health status, financial accounts, track of whereabouts of the individual, and other sensitive information. For example, if you manage a medical and health company that possess any such information, your company will be subject to the enhanced rules, which include the followings. One, you must have specific purpose and sufficient necessity and take strict protective measures before processing sensitive PI. So compare with the clear and reasonable purpose standard of non-sensitive PI. This is a higher standard. Secondly, you must obtain a separate consent from the relevant individual or written consent if any law or regulation requires it. This means you cannot rely on a collective consent. You must also inform the individual of the necessity of processing his or her sensitive PI and the impact on his or her rights. It means your notification shall contain more details than the notification to individuals for non-sensitive PI. And you must prepare special rules for processing PI of minors under the age of 14. Finally, you must conduct PI protection impact assessment in advance.
One question that often comes up in the Australian context is whether vaccination status information would constitute sensitive personal information.
Yes, I think according to the definition, this vaccination information should fall within sensitive personal information. But also according to the PIPL, there are certain circumstances that you can have exemption for getting the individual consent. For example, it is for public health purpose, right? In the case of COVID-19, if a government authority wants to protect the public health, so they can collect information about vaccination of an individual without getting their consent.
Would this apply to an Australian government, or is it just the PRC government?
Well, I think this is a good question. It's not clearly provided in the law, but I think in practice, if a PRC individual is entering into Australia, then it will have to provide a vaccination information, right? Are you saying?
Yeah. Yep, that would be correct. Or potentially if a Chinese national were to enter Australia for the purposes of employment, that employer may require vaccination status information.
I think, as I said, it's not clearly provided, but I think according to the principle, the Australian company will need to comply with the PIPL by the same standards. And according to the PIPL, if it's for public health purpose, you can collect that information, but you should tell the relevant individual that you are doing this for the public health purpose, and you should limit the use of this information strictly for that purpose only.
Has the PRC authority issued the model contract template for transferring personal data from China to overseas?
Not yet. So currently, many of our clients are using the GDPR template, or they engage PRC lawyers to review their GDPR template to make amendments to comply with the PIPL.
Now, Wayne, I've been wondering, I'm here recording this podcast in Australia. If I were to breach the PIPL, what exactly could China do about it? What are the consequences for Australian businesses for breaching the PIPL?
I think there are two issues here. Firstly, what is the consequence under the PIPL? And secondly, how can they enforce it against an Australian company? Regarding the first issue, what are the consequences? There are civil liabilities, administrative liabilities, or criminal liabilities. Regarding civil liabilities, the Australian company may be liable to pay damages to the victims. And regarding administrative liabilities, the relevant PRC authority may issue rectification order, warning, or order to suspend the relevant business, order to suspend or terminate the service of your software program, or prohibit the responsible persons from taking up directorship or confiscate the illegal income or impose fines. Yeah. In serious circumstance, there could also be criminal liabilities. So what is serious circumstance according to the PIPL? The PI processor may face a fine of up to RMB 50 million or 5% of its revenue in the preceding year. So this is a very serious consequence.
Yeah.
But the PIPL has not set out what is serious consequence. The PIPL has not set out the standard of serious circumstance. So what is the serious circumstance will depend on the discretion of the authority for now. The next issue is about the burden of proof. So in legal actions, the burden of proof will be on the PI processor. You will be held liable to pay damages to the relevant individuals if you cannot prove your innocence. The damages shall be determined based on the loss of the victim or the benefits gained by the PI processor. Another notable issue is class action is available under the PRC law. For example, the public prosecutor, the Consumer Protection Organization, or the organization determined by the CAC, the PRC regulator, they may initiate proceedings at court on behalf of a large number of individuals whose interests have been infringed. Okay, the above are about the consequences, and the other issue is about how to enforce the PRC, how to enforce the penalties in Australia. Firstly, we know that a PRC court judgment cannot be recognized and enforced in Australia automatically. You need to apply to the Australian court for recognition and enforcement of PRC court judgment. And in relation to the civil actions or administrative penalties in China, it depends on whether this Australian company has any assets or business in China.
So presumably if the Australian company has assets in China, then the CAC or the Chinese authorities can take over those assets in order to make good the fines?
Yes, in a serious circumstance, it could be possible. And there are also a risk that the Australian company may be put on a blacklist by the PRC authority if they have infringed the interests of PRC individuals in relation to their personal data.
Is the legislation retrospective or does it apply only from November the 1st last year?
It only starts to apply from November 1st of last year.
Wayne, have you seen much activity in terms of Australian businesses running into challenges in relation to the PIPL?
I think currently, because the PIPL is relatively new, it was only promulgated in November of last year, and many of the implementation rules are yet to be released. So for now, I think many Australian companies are reviewing their policies or their standard templates to make sure that they will comply with this law. But we still haven't seen a lot of enforcement proceedings against them. But it could be a risk in the future.
Thank you for your time, Wayne. It's been fascinating talking to you, and it will be interesting to see how it evolves over the coming months.
Yes, thank you. It's my pleasure of talking to you.